Welcome, and thank you for joining us. Please note that this AI-generated podcast is intended solely for general learning and educational purposes. While we strive to ensure accuracy, the AI may occasionally produce errors or incomplete information. We strongly encourage you to consult qualified professionals and conduct your own due diligence before making any legal, financial, or business decisions based on the content presented here. Also, if you find this content valuable, we kindly request you to like the video, subscribe to the channel, and activate the notification bell to receive updates on future episodes. Let's begin.
Welcome back to the deep dive. Today we're jumping into something, well, it sounds almost like a legal paradox, doesn't it? A real twist from the world of automotive tech.
It really does.
Imagine this. You spend years, just years, on an invention. You get the patent, you go to court, and you actually win. You get the court to agree. Your patent covers a really broad range of technology.
You feel pretty good at that point, right? Like you've secured everything.
Exactly. Victory. But then,
Yeah.
that exact win, that broad scope you fought for, it becomes the very reason your entire patent gets thrown out. Invalidated. How on earth does that happen?
It's a classic, well, maybe not classic, but a really potent example of a key principle in patent law. It's all about enablement. You know, the ambition to claim your invention as broadly as possible is totally understandable.
Sure, you want maximum protection.
Of course, but, and this is the big but this case highlights, the ambition has to be backed up, really solidly backed up, by what you actually wrote down in the patent. How to make it work. It's a super delicate balance.
Okay, that sets us up perfectly. That's our mission today. To really get into the weeds of a major ruling from the United States Court of Appeals for the Federal Circuit.
And that's the Court for Patent Appeals in the U.S., so their decisions carry a lot of weight.
Exactly. We're not just looking at legal history here. This is about a crucial lesson, the tightrope walk, between claiming broadly and actually explaining how to do everything you've claimed. We'll dig into this specific case, why the judges ruled like they did, and what it means for anyone inventing stuff today.
Right. You're going to see how wanting too much protection without providing the detailed instructions can kind of backfire spectacularly. We'll cover things like, what exactly is a patent claim in this context, and this really important idea of undue experimentation.
Undue experimentation. Okay.
Yeah. You'll see how the specifics in the patent document, or sometimes the lack of specifics, can be the difference between a valid patent and, well, an invalid one. It boils down to, if you say you can do it, you better have shown how you can do it, clearly.
Let's lay out the basic facts then. This case we're diving into, it's from the United States Court of Appeals for the Federal Circuit. You said it's the Court for Patents.
Pretty much, yeah. It hears appeals from all the district courts across the country on patent issues, plus some other specific areas. So its rulings create uniform patent law nationwide, which is huge.
Got it. And the judgment we're looking at?
It was handed down September 6, 2007. The case numbers are 2006, 10-13, and NECIS 2037. And the number of parties involved is just staggering. Really tells you how high the stakes were.
Okay, who are the main players?
All right, so the appellant, that's the one who lost in the lower court and was appealing, and also the original plaintiff was Automotive Technologies International, Inc. We'll just call them ATI.
ATI. Got it. They held the patent.
Correct. And they were trying to enforce it against, well, basically the entire automotive industry, it feels like. The appellees, the defendants, included BMW, Daimler Chrysler, Ford, Honda, Hyundai, Mazda, Saab, Siemens, Toyota, GM, Volkswagen, Nissan.
Wow. Okay, just keep going.
Yeah. Calisthenic Kansei, TK Electronics, TRW Automotive, Delphi Automotive Systems, Kia, Bosch Automotive, a massive list.
So ATI was really trying to take on everyone.
They really were. It shows you this wasn't some minor technicality. It was about a core technology impacting pretty much every major car manufacturer and supplier.
And who are the judges hearing this appeal at the Federal Circuit?
The panel was circuit judges Lorry, Rader, and Prost. Judge Lorry wrote the main opinion for the court.
Okay. And this came up from which lower court?
It was appealed from the U.S. District Court for the Eastern District of Michigan. Judge Robert H. Cleland was the district judge who handled the case initially, including those key early rulings.
Right, and behind the scenes, you've got all the lawyers.
Oh, yeah, armies of them. For ATI, you had Michael Baniak, Andrew Kuchinowski, and Michael Gannon fighting their corner.
A tough job, given that list of opponents.
Definitely. And on the defendant side, multiple top firms, Kenneth Gallo, Drew Winteringham, Mark Rue represented one group. Charles Shifley, Binal Patel, Theodore Field were there for Delphi and GM. John Feldhaus, Pavan Agarwal, Mary Calkins for Nissan and Calsonic Kansei. It just underscores the scale and importance of this fight.
Absolutely. Okay, so let's get to the tech itself. What was this invention at the heart of U.S. patent 5,231,253?
Right. The patent was titled Side Impact Sensors. Pretty self-explanatory. It's about crash sensors, specifically designed to deploy things like airbags during side collisions. Hugely important safety tech.
Side impacts are notoriously dangerous. What was the problem with the sensors before ATI's invention?
So the common sensors back then were often called crush sensors. They were typically put inside the side door.
And they worked by literally being crushed.
Yeah, basically. The physical deformation of the sensor during a crash would complete an electrical circuit, and boom, airbag deploys. Very direct mechanical action.
But there was a flaw, a big one.
A critical flaw, yes. These crush sensors might not trigger if the impact wasn't directly on the door where the sensor was located. Imagine the impact hits the pillar next to the door, or maybe slightly forward or behind it. The car could be crumpling significantly, posing a danger. But if that specific sensor wasn't physically crushed,
the airbag might not deploy or deploy too late. That's a serious gap.
Exactly. So ATI's idea was a big shift. They proposed using what are called velocity-type sensors for side impacts.
How do those work differently?
Instead of waiting for physical crushing, these sensors measure the change in velocity, basically, how quickly the car structure is accelerating sideways during the crash. If that change crosses a certain threshold, it triggers the airbag. It's measuring the dynamics of the crash itself, not just the local deformation.
That sounds like a smarter approach, but you mentioned it went against conventional wisdom.
It really did. At the time, velocity sensors were well established for frontal crashes, but the thinking was that side impacts happen so fast they're incredibly impulsive that a velocity sensor just wouldn't react quickly enough.
Too slow for the job.
That was the belief, that by the time the velocity change was significant enough to measure reliably, it'd be too late for the airbag to protect the occupant effectively. But ATI's inventors claimed they'd figured it out. They said they discovered that, if designed properly, velocity sensors could work fast enough for side impacts. They presented this as a breakthrough, something unexpected.
And that claim of being a breakthrough became important later, didn't it?
Hugely important, yes. It framed the whole context for how much detail they needed to provide in the patent.
Okay, so let's look at Claim 1, the main claim. What did it actually describe?
Claim 1 laid out the basic components. First, a housing, just the container. Second, a movable mass inside, the part that actually reacts to the crash acceleration.
Here's it filament.
Right. Third, what they call means responsive to the movement of that mass. Once the mass moved past a certain point, this means this mechanism would trigger the airbag or other protection system. It's a functional description.
Meaning it could cover different ways of doing that triggering.
Exactly. And fourth, means for mounting the sensor housing, specifically mentioning mounting it on a side door or on the side of the vehicle, somewhere between the front and rear wheels.
Now, this is where it gets really interesting and kind of sets up the whole problem. The patent described two different types of sensors, but in very different ways, right? Mechanical and electronic.
Precisely. And the difference in description is key. For the mechanical sensors, the patent went into great detail. We're talking 2 full columns of text, 5 different figures, showing how they worked.
Like actual diagrams?
Yeah, clear diagrams, showing things like a little flapper moving to hit an electrical contact when the crash pulse hit it. It even discussed technical details, like needing greater insensitivity for short, impulsive velocity changes, and mentioning specific types like inertially damped, spring mass, or viscously damped sensors. Very thorough.
So for the mechanical ones, it was like getting the blueprints. You could probably build one based on that description.
You can certainly understand how it's supposed to work in detail. But then you have the electronic sensors.
And how are they described?
It was night and day. The patent mentioned electronic sensor assembly, sure, but the only drawing, figure 11, was explicitly labeled a conceptual view. It basically just showed a box labeled sensor with a mass inside.
Just a box, no circuits, no details.
Nope. The text was just as vague. It said the mass's motion can be sensed by a variety of technologies using, for example, optics, resistance change, capacitance change, or magnetic reluctance change, and that the output could be processed. That was pretty much it.
So no explanation of how you'd use optics or capacitance to sense the motion in a way suitable for side impact, or how you'd process that signal reliably.
Exactly. It lacked the specific operational details, the circuitry, the processing logic needed to actually make it work for that challenging side impact scenario. This huge difference in detailed mechanical versus vague electronic became the absolute crux of the legal battle over enablement.
Okay, that contrast is critical. Let's trace the journey through the courts then. It started back in May 2001 when ATI sued basically everyone.
Huh? Yeah, pretty much. They filed infringement suits against that long list of car companies and suppliers.
The first big step in court is claim construction, the Markman hearing. That happened in March 2004. What was the outcome there?
This was actually a win for ATI initially. Remember, that means responsive term, the part that triggers the airbag. The district court agreed with ATI that this term covered both the detailed mechanical sensors and the vaguely described electronic ones.
Even though the electronic description was so vague.
Yes. The court acknowledged the detail for the mechanical parts and the vagueness of Figure 11 for the electronic ones, but still interpreted the claim broadly to include both. ATI had pushed hard for this broad interpretation, and they got it. This seemed like a big win, expanding the potential reach of their patent.
Okay, so victory number one for ATI. What about the means for mounting? Where could the sensor be placed?
The court clarified that too. It said the sensor had to be capable of being mounted both on a side door and somewhere on the vehicle side between the wheels. Not necessarily in both places at once, but designed with the capability for either location.
And important.
Importantly, it defined the side of the vehicle as the side perimeter structure and explicitly said this excluded the floor pan. That location detail became crucial later.
So ATI leaves the Markman hearing with a broad claim scope. Things are looking good. But then we get to the actual infringement arguments. What happened in late 2004, early 2005?
Well, some defendants started getting off the hook. Siemens, Ford, Hyundai won summary judgment, meaning the court decided without a full trial that they didn't infringe.
Why not?
Because their sensors were mounted on the vehicle floor. And remember, the court had specifically excluded the floor from the side perimeter structure defined in the claim construction. So literal infringement was out.
Could ATI argue they were still essentially equivalent?
They tried, using the doctrine of equivalence. But the court shut that down, too. It said allowing floor-mounted sensors to be equivalent would vitiate, basically, render meaningless the claim's specific limitation to the side structure. You couldn't use equivalence to just ignore a clear limitation in the claim.
Makes sense, but not everyone got off.
No. Calsonic and Nissan didn't win summary judgment. Their sensors were between the doors, and there was still a factual question about whether those sensors were capable of being mounted on a side door. So their infringement case was still live. But the bigger storm was brewing on the validity front.
Right. July 2005. This is where it all started to unravel for ATI. The defendants hit back hard, questioning if the patent was even valid in the first place. Two main attacks, you said.
Two main attacks, both based on Section 112, Paragraph 1 of the Patent Act. The first was on the written description requirement.
Which means?
It means the patent specification has to show that the inventor actually possessed the full invention they're claiming at the time they filed. The defendants argued ATI hadn't adequately described mounting the sensor between the centers of the front and rear wheels.
Even though the claim mentioned it.
Right. They argued the description wasn't detailed enough for that location. They also pointed out an inconsistency. The patent text itself seemed to argue that sensors had to be on the door for side impacts to work properly, which contradicted the broader claim allowing mounting elsewhere.
And the district court?
The district court agreed with the defendants on this. It found claims 144 invalid for lacking adequate written description for those broader mounting locations. Big blow number one.
Okay, so even before getting to how it works, there was a problem with just describing what was claimed. And then came the second attack, the big one. Enablement.
Exactly.
Yeah.
Also under Section 112, Paragraph 1, this requires the patent to teach someone skilled in the art, basically, another expert in the field, how to actually make and use the full invention without needing excessive or undue experimentation.
And the argument here focused squarely on those electronic sensors.
Precisely. Delphi led this charge, arguing that while the mechanical sensors might be enabled, the patent utterly failed to teach anyone how to make and use the electronic sensors it also claimed.
Because of Figure 11 and the vague text?
Yes, the court zeroed in on that. The vagueness of Figure 11, the inventor calling it conceptual, the lack of any reasonable basic enabling structure, showing how to adapt known electronic tech, like optics or capacitance, for the specific, tricky demands of side impact sensing. It just wasn't there.
How did the court gauge undue experimentation? Is there a test for that?
Yeah, they used a set of factors from a key case called In Re Wands. These include things like how much experimentation is needed, how much guidance does the patent give, are there working examples, how predictable is the technology,
Right.
what did people already know, the prior art.
And for ATI's electronic sensors.
All the factors pointed the wrong way for ATI.
Huh.
Little guidance, no working examples, and ATI itself had called side impact velocity, sensing a new, unpredictable breakthrough field. So the court concluded it would require undue experimentation to figure out the electronic sensors based only on the patent.
But ATI must have argued, hey, look, our mechanical sensors are fully enabled. That should be enough.
They absolutely argued that. They said enabling one mode should cover the whole claim. But the district court flatly rejected that because ATI had fought tooth and nail during claim construction to get that broad interpretation covering both mechanical and electronic sensors. The court said, essentially, you wanted this broad scope. Fine. But now you have to show you enable that entire broad scope. Enabling just the mechanical part wasn't enough to support a claim covering distinctly different electronic sensors too.
Wow. So their win in claim construction set them up for a fall on validity.
That's the irony right there. They won the battle over scope, but lost the war over enablement.
Okay, so the district court invalidates the patent on both written description and enablement grounds. ATI appeals to the Federal Circuit. What happens there?
The Federal Circuit completely affirmed the district court's invalidity ruling based on the lack of enablement for the electronic sensors. They didn't even need to address the written description issue because the enablement failure was so clear and dispositive.
And they reviewed the enablement question de novo.
Yes, meaning they looked at the legal question of enablement fresh, without giving special deference to the district court's legal conclusion, though they'd only overturn factual findings if they were clearly erroneous. And they started, of course, with the presumption that the patent was valid. So the defendants needed clear and convincing evidence to invalidate it.
Which the Federal Circuit found they had.
Overwhelmingly so on the enablement issue. The court reiterated the basic rule. The patent has to teach how to make and use the full scope of the claimed invention without undue experimentation.
And critically, on appeal, everyone agreed the claim scope included both mechanical and electronic sensors, right? That wasn't debated anymore.
Correct. That broad scope, which ATI had won earlier, was now undisputed. And it was also undisputed that the mechanical sensors were enabled. The whole fight now centered on whether the electronic sensors were enabled too.
Which brings us back again to that stark difference in disclosure. How did the Federal Circuit describe it?
They really hammered on it. 2 columns and 5 figures for the mechanical part detailed clear. 1 short paragraph and that single conceptual box diagram, figure 11, for the electronic part. No details on circuitry, no specifics on how to adapt those variety of technologies for side impact.
Just listing optics, capacitance, resistance wasn't enough.
Not even close, according to the Federal Circuit, especially because ATI itself had stressed how novel and unexpected using velocity sensors for side impacts was. The court basically said, if you're claiming a breakthrough in a new field, you can't just vaguely point to existing technologies and expect someone skilled in the art to do the heavy lifting of figuring out how to make it work in that new, difficult context.
They cited that Gentech case.
Yes, Gentech v. Novo Nordisk. The key line there, which the Federal Circuit quoted, is, it is the specification, not the knowledge of one skilled in the art, that must supply the novel aspects of an invention in order to constitute adequate enablement. General knowledge can fill small gaps, but it can't substitute for the core teaching of the novel part of your invention.
So, because ATI called it a breakthrough and a new field, they raised the bar on themselves for how much detail they needed to provide.
In effect, yes. They couldn't have it both ways, claim it's revolutionary, and then say the details are obvious. The court saw the patent's description of electronic sensors as merely a starting point, a direction for further research, not an enabling disclosure.
Did the Federal Circuit also find evidence of undue experimentation?
Absolutely. They pointed to Delphi's expert testimony, which detailed the great deal of experimentation needed figuring out how to sense the mass motion properly for data output and how to process that data correctly for the unique timing demands of side impacts.
And ATI's own inventor and expert didn't help their case much.
Not at all. The inventor, Breed, admitted he'd never built an electronic side impact sensor and that they weren't commercially available back then. They'd have to be developed. And ATI's own expert, Dr. Dix, while claiming it could be done, was criticized for being too general. He didn't explain what tests or what specific adaptations would be needed. Just saying it's possible wasn't enough.
And the court specifically rejected the one-enabled mode is enough argument again, citing Liebel-Flarsheim.
Yes, they explicitly relied on Liebel-Flarsheim. Just like in that case where enabling an injector with a pressure jacket didn't enable the claim covering one without a jacket, here, enabling the mechanical sensor didn't enable the claim covering the distinctly different electronic sensor. The court was very clear. The specification must enable the full scope of the claim.
Which led to that quote about the irony.
Exactly. Quoting Liebel-Flarsheim, the court highlighted the irony. ATI fought for and won a broad claim scope covering electronic sensors, but then couldn't meet the enablement requirement for that very scope. Claims must be enabled to correspond to their scope. It's a powerful cautionary statement.
And because the claims were invalid for lack of enablement, the infringement questions just became irrelevant.
Totally moot. You can't infringe an invalid patent. So the Federal Circuit didn't need to address ATI's infringement appeal or the cross appeal from Celsonic and Nissan. The invalidity finding ended the case, and it was a unanimous decision by Judges Laurie, Rader, and Prost. No dissents.
So stepping back, what's the big legal takeaway here? What's the significance of this ATI decision?
Well, first, it's a very strong reinforcement of the enablement requirement. Just hinting at something isn't enough. Your patent has to genuinely teach the full scope of what you're claiming.
And the full scope doctrine is key.
Absolutely. If your claim covers multiple different embodiments, like mechanical and electronic sensors here, you have to enable all of them. You can't just enable the easy one and hope it covers the rest. You don't get broad claims without broad enabling disclosure.
It also really highlights that tension between claim construction and validity, doesn't it?
Definitely. Winning a broad claim interpretation can feel great initially, but it sets a higher bar for enablement. It can be a Pyrrhic victory if your disclosure doesn't support that breadth. Patent strategy has to consider both infringement and validity right from the drafting stage.
And the point about novelty demanding detail seems crucial too.
Very much so. If you're claiming a breakthrough or applying tech to a new field, you can't just rely on general knowledge. You need to spell out how your breakthrough works in that new context. The specification has to provide the core teaching.
Plus, it gives us a clear example of how courts look at undue experimentation, using those Wands factors. Generic expert opinions are enough. You need specifics.
Right. The court needs to see evidence about the amount of work, the lack of guidance, the unpredictability. It's a factual analysis.
So if you had to boil it all down to the single most important takeaway,
It has to be that irony the court talked about. The enablement paradox, maybe. Your ambition for broad patent claims winning that scope battle can be exactly what sinks your patent if your specification doesn't fully teach how to make and use everything covered by those broad claims without undue experimentation.
you have to earn your claim scope with your disclosure.
Perfectly put, the patent system is a bargain. You get exclusivity, but only if you give the public a full enabling disclosure in return. You can't claim what you haven't properly taught.
So we've seen how ATI's potentially groundbreaking patent met its end, not because the idea wasn't novel, but because the description didn't fully support the breadth of the claims, particularly for the electronic sensors.
It's a sobering lesson. For inventors, for patent lawyers, for anyone involved in innovation, it really drives home that you need diligence in disclosure to match your ambition in claiming. Having the great idea is step one. Clearly teaching the full scope of it is just as critical for a strong patent.
It makes you wonder then about strategy. Does this case suggest inventors should maybe start with narrower claims they know are fully enabled and perhaps file later patents for broader aspects as they develop them?
That's definitely one strategy, building incrementally.
Yeah.
Or do you go for the broad claims up front and just make absolutely sure your specification is incredibly detailed across the board, even for embodiments that are more conceptual at the time?
It's tricky, especially for really new disruptive technologies where maybe you can't fully detail every possible variation right at the beginning because the field itself is still evolving.
It's a constant challenge. There's always that tension between wanting the broadest possible protection early on and ensuring your patent can withstand validity challenges later. It involves predicting the future a bit, both technologically and legally.
A fascinating balancing act. Well, that wraps up our deep dive into this critical enablement case. A huge thanks for walking us through that.
My pleasure. It's a really instructive case.
To everyone listening, keep digging, keep questioning. Thanks for joining us on the deep dive. We'll see you next time.